What's going on YouTube? Listen up, young elder gang. This is Joe Blow, at you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In this video, you will find history, definitions, scripture, information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind, this content used in this video is intended for entertainment, educational, and informational purposes only. The information provided on this video is not to be construed as legal advice. We are not legal attorneys. For legal advice, please seek out a licensed legal advisor or attorney. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. Alright, let's get started. Why aren't more people talking about the roller coaster that is law school's first day? Let's dive in. Welcome to the wild ride of law school. First things first, you'll learn how to read legal opinions, or as I like to call them, brain-bending bedtime stories. No summaries, no cliff notes, just you and the dense text. You'll also get your crash course in Legal System 101 through subjects like civil procedure and criminal law. Think of it as learning the rules before playing the game. Legal research and writing? Yep, your new best friends. You'll be spending quality time with these, crafting ironclad arguments and navigating the labyrinth of legal databases. But here's the kicker: learning to think like a lawyer. You'll master issue spotting, dissecting laws, and applying them to real-world problems. It's like becoming a legal detective. And don't forget the Socratic method, professors grilling you with questions to sharpen your critical thinking. Fun times, right? So buckle up, future attorney. Day one is just the beginning of your legal adventure. A legal opinion is a written or verbal analysis of a legal position by a legal professional that is intended to be relied upon by the recipient. It can include conclusions or recommendations and is often used to inform the recipient of the legal implications of a transaction or matter. Here are some examples of when a legal opinion might be used. Financing transactions. A lender's lawyers might issue a legal opinion to confirm that the borrower's finance documents are valid, enforceable, and comply with local laws. Venture capital. A legal opinion can help venture capital firms make informed investment decisions by identifying legal risks and issues. Bankruptcy. A trustee might obtain a legal opinion from a solicitor to confirm the validity of a security interest before acting for a secured creditor. Judicial rulings. A judge might write an opinion that explains the rationale and legal principles for a ruling in a case. A legal opinion is not a substitute for legal advice, which is often more extensive. In law, a legal opinion is in certain jurisdictions a written explanation by a judge or group of judges that accompanies an order or ruling in a case, laying out the rationale and legal principles for the ruling. A legal opinion is not a substitute for legal advice, the main key difference being that a legal opinion is an attorney's analysis based on past or present facts, while legal advice is an attorney's counsel and guidance as to what future actions the client should take. Although there are a variety of opinion letters, the most common include the remedies opinion or the enforceability opinion, the non-consolidation opinion, and the entity status opinion. Critical thinking is the process of analyzing, evaluating, and making judgments about information to form a sound conclusion. It involves questioning, interpreting, and synthesizing information from a variety of sources, such as observation, experience, and communication. Critical thinking is important in many subjects and disciplines including science, engineering, the arts, and humanities. It's also a highly valued skill by employers. Here are some tips for critical thinking. Be open-minded. Remain inquisitive and avoid jumping to conclusions. Ask questions. Dig deep and don't accept information at face value. Be objective. Keep your own biases and perceptions in check. Consider multiple points of view. View phenomena from different perspectives. Be willing to change your mind. When new facts come to light, be prepared to change your beliefs. Critical thinking is the analysis of available facts, evidence, observations, and arguments in order to form a judgment by the application of rational, skeptical, and unbiased analyses and evaluation. In court proceedings, a defendant is a person or object who is the party either accused of committing a crime in criminal prosecution or against whom some type of civil relief is being sought in a civil case. Terminology varies from one jurisdiction to another. Defendant, in criminal cases, is the person accused of the crime. In civil cases, the defendant is the person or entity that is being sued by the plaintiff. In certain types of actions, the defendant is called the respondent. However, the term respondent is usually used to designate the person responding to an appeal. In a criminal case, the defendant is the person accused of committing a crime. For example, if someone is accused of murder, the government will bring a criminal case against them. The government is the plaintiff, and the accused is the defendant. In the trial court, the first name listed is the plaintiff, the party bringing the suit. The name following the V is the defendant. If the case is appealed, as in this example, the name of the petitioner, appellant, is usually listed first, and the name of the respondent, appellee, is listed second. The legal term plaintiff refers to the party who initiates the legal claim and seeks relief or compensation. The plaintiff's role is to present evidence and arguments to support their claim and prove their case to the court. If someone is the victim of a crime and the person accused of that crime is arrested, the plaintiff is not the victim. The victim was the target of the crime, but the actual plaintiff is the government body bringing charges against the alleged perpetrator. A plaintiff is the party who initiates a lawsuit before a court. By doing so, the plaintiff seeks a legal remedy. If this search is successful, the court will issue judgment in favor of the plaintiff and make the appropriate court order. A plaintiff is the party who initiates a lawsuit in a civil matter. The plaintiff may be an individual or an entity. A plaintiff files a complaint with a court against the defendant, initiating the action. In law, reasonable doubt is a legal term that refers to a lack of evidence that prevents a jury or judge from convicting a defendant of a crime. It's the standard of proof that must be met to secure a guilty verdict in a criminal case. A reasonable doubt is a fair, logical, and actual doubt that's based on reason and common sense. It's more than a mere possible doubt or speculation. The prosecution must prove the defendant's guilt beyond a reasonable doubt. This means that the evidence must be so convincing that no reasonable person could have any doubts about the defendant's guilt. The accused is presumed innocent until guilt is proven beyond a reasonable doubt. The standard of proof is moral certainty, not absolute or mathematical certainty. Reasonable doubt is insufficient evidence that prevents a judge or jury from convicting a defendant of a crime. If it cannot be proved without a doubt that a defendant in a criminal case is guilty, then that person should not be convicted. A reasonable doubt exists when a fact finder cannot say with moral certainty that a person is guilty or a particular fact exists. It must be more than an imaginary doubt, and it is often defined judicially as such doubt as would cause a reasonable person to hesitate before acting in a matter of importance. For example, when some say that beyond a reasonable doubt should be understood to mean that the jurors should not convict a defendant unless they conclude that there is at least a very high probability, for example, 95%, that he committed the crime, they might mean that if the same evidence was presented to a jury. The burden of proof is a legal standard that requires parties to provide evidence to demonstrate that a claim is valid. 3 levels of the burden of proof: beyond a reasonable doubt, a preponderance of the evidence, and clear and convincing, determine the level of evidence required for a claim. For example, when some say that beyond a reasonable doubt should be understood to mean that the jurors should not convict a defendant unless they conclude that there is at least a very high probability, for example 95%, that he committed the crime, they might mean that if the same evidence was presented. An action in law is a judicial proceeding or a lawsuit that is brought to protect a right, enforce a right, or punish a crime. The party bringing the action is called the plaintiff or prosecution. A legal action can also refer to any action taken before the law. For example, if someone is injured in a car accident and sues the other driver, they are taking legal action. A cause of action is a set of factual elements that allow for a legal remedy. These elements can come from a constitution, statute, judicial precedent, or administrative regulation. An action refers to a judicial proceeding. If a party brings a civil or criminal case against you, an action has been brought against you. The party bringing the action is the plaintiff/prosecution respectively. Law in action is a legal theory associated with legal realism that examines the role of law not just as it exists in the statutes and cases, but as it is actually applied in society. As at law schools everywhere, the focus is on appellate opinions. However, a professor who focuses on law in action is likely to go past the holding of the case to look at more questions such as, how might the parties on the losing end of the case respond? Will the rule change their future behavior? Who will enforce the rule? Or what was the cause of the underlying dispute? will be addressed. One similarly, clinical education and clinical skills courses take on a more important role for students who get to integrate their personal experiences with the classroom work. It is a concept that is founded in the presumption of innocence. Every person is presumed innocent until proven guilty. Broadly speaking, reasonable doubt is the level of certainty that a juror must have before they can find a defendant guilty of a crime. A case in law is a legal proceeding or dispute between opposing parties that can be resolved by a court or other legal process. Cases can be civil or criminal and are also known as actions, suits, or controversies. Civil cases usually involve two parties of equal status, such as a citizen and a citizen or a citizen and a corporation. Criminal cases usually involve two parties of different status, such as the state represented by the prosecutor and the defendant, who is typically an individual or corporation. Case law, the use of court decisions to determine how other laws should apply in a given situation. Winning a case can mean a victory in court or a settlement out of court. Types of criminal cases. In California, criminal cases are categorized as infractions, misdemeanors, or felonies. Case law, also used interchangeably with common law, is a law that is based on precedents, that is, the judicial decisions from previous cases, rather than law based on constitutions, statutes, or regulations. Case law uses the detailed facts of a legal case that have been resolved by courts or similar tribunals. Case law, the use of court decisions to determine how other law, such as statutes, should apply in a given situation. For example, a trial court may use a prior decision from the Supreme Court that has similar issues. Chambers, a judge's office. Charge, the law that the police believe the defendant has broken. You are probably familiar with the Miranda warning, in which officers recite a person's right to remain silent. The requirement that police must issue such a warning to a criminal suspect in custody before beginning an interrogation came from the U.S. Supreme Court's decision in Miranda v. Arizona in 1956. A suit in law, also known as a lawsuit, is a legal action where a plaintiff seeks to enforce a right or claim against a defendant. The plaintiff files a complaint with the court, alleging that the defendant failed to perform a legal duty and caused harm. The defendant then responds to the complaint and the court sets a timeline for the case. The word suit comes from the Old French word suite, which means to pursue or to follow. There are many types of suits, including civil lawsuits and criminal lawsuits. Civil lawsuits include cases for breach of contract, personal injury, divorce, child custody, and lawsuits against government officials. Criminal lawsuits, when the government prosecutes someone for a crime. A common term for a legal action by one person or entity against another person or entity to be decided in a court of law, sometimes just called a suit. The legal claims within a lawsuit are called causes of action. See also, case cause of action suit. In a court of law, a suit is a case in which someone tries to get a legal decision against a person or company, often so that the person or company will have to pay them money for having done something wrong to them. In general, a suit refers to a legal case. Someone threatening to file a suit is different from an actual filed lawsuit. A filed lawsuit means that formal paperwork involving a demand or legal claim has been submitted to the courts. Simply filing a lawsuit does not mean that the lawsuit is legitimate. Suit, n generic term for any filing of a complaint or petition asking for legal redress by judicial action, often called a lawsuit. In common parlance, a suit asking for a court order for action rather than a money judgment is often called a petition, but technically it is a suit in equity. After a lawsuit is filed, the case enters a crucial discovery stage. This period, often lasting several months, is when both sides exchange information and evidence relevant to the case. The purpose of discovery is to allow each party to learn about the other side's claims, defenses, and supporting facts. Discovery has multiple meanings, including the act of finding something and the legal process of exchanging information in a court case. Finding, the process of discovering something, such as a place, information, or object. For example, you might discover a live lizard in a birthday box. Legal process, the formal process in which parties in a court case exchange information about the case. The purpose of discovery is to make the parties aware of the evidence that may be presented at trial. In a legal context, discovery involves gathering evidence. The plaintiff uses discovery to gather evidence to prove their case, while the defendant uses it to defeat the plaintiff's case. Obtaining information. Parties can use discovery to obtain information from the other party, such as relevant documents, emails, medical records, or paycheck stubs. Inspections and examinations. Discovery can include inspections of property or medical examinations. Discovery rules vary by jurisdiction. Discovery is how you gather the evidence you will need to prove your case as plaintiff or defeat the plaintiff's case as a defendant. You use discovery to find out things like what the other side plans to say about an issue in your case, what facts or witnesses support their side. If you are the plaintiff in a case, you have the burden to prove your case by stronger evidence than the other side. If you are a defendant in a case, you have to raise enough doubt about the strength of the plaintiff's case to make the judge or jury decide your side is stronger. Discovery is how you gather the evidence you will need to prove your case as plaintiff or defeat the plaintiff's case as a defendant. You use discovery to find out things like what the other side plans to say about an issue in your case, what facts or witnesses support their side, what facts or witnesses support your side, what information or documents could be used as evidence. To get information from the other side and use it as part of your trial, you must follow court rules and ask for information and documents in writing using a specific format. Some forms of discovery are relatively easy to do and involve using court forms with standard questions. Others are more difficult and benefit from getting assistance from a lawyer. Another way you can get information from the other side is to have them give sworn testimony outside of court before the trial in a deposition. Taking a deposition is complicated and expensive. It requires knowledge of the law and rules of evidence. If you're interested in taking a deposition, seriously consider asking a lawyer for help. If you cannot or do not wish to hire an attorney, you can also visit your local law library and ask a librarian to recommend a how-to book on how to take a deposition. It can be a very costly mistake to conduct a deposition without adequate preparation. There are other types of discovery as well, such as requests for physical, medical, or psychiatric examination. These can be complex and expensive. You can get more information about these types of discovery from a lawyer or law library. Request evidence and testimony from individuals who are not involved in the lawsuit. As part of discovery, sometimes you need to have an individual or company who is not a party to the case produce documents or business records. To do this, you use a subpoena. You may receive requests for discovery from the other side. As part of the lawsuit, the other side may send you requests for information or evidence. If this happens, you have specific requirements and deadlines for responding. Deposition, a witness or party's testimony taken under oath outside the courtroom. A deposition is a formal, out-of-court interview where a witness or party in a legal case is sworn in and answers questions under penalty of perjury. Depositions are part of the pre-trial discovery process and are used to gather information and evidence from the opposing side. Here are some key aspects of a deposition. Purpose. Depositions are used to learn more about the case, including who is involved, what happened, why it happened, and how it happened. They are also used to assess the strengths and weaknesses of the opposing party's case. Process. A deposition is conducted by an attorney who asks the witness questions. The witness is called the deponent. A court reporter is usually present to transcribe the testimony, and the deposition may also be audio or video recorded. Parties involved. The main parties involved in a deposition are the deponent, the opposing attorney, the deponent's attorney, and the court reporter. Length. Depositions typically last less than 7 hours. Location. Depositions are usually held in the office of one of the lawyers in the case. Transcript. The deponent usually has the right to read and sign the transcript before it is filed with the court. Use in court. The testimony from a deposition can be used as evidence in court, especially if the witness is unable to attend the trial or changes their story. A jury is a sworn body of people convened to hear evidence, make findings of fact, and render an impartial verdict officially submitted to them by a court or to set a penalty or judgment. Juries developed in England during the Middle Ages and are a hallmark of the English common law system. A jury is a group of people who are chosen to decide the facts of a case and reach a verdict in a trial. Role. In a criminal case, a jury decides if the accused is guilty or not guilty. In a civil case, a jury decides if the defendant is liable or not liable. Responsibilities. Jurors listen to testimony, review evidence, and apply the law as explained by the judge. They are responsible for determining the facts of the case based on the evidence presented. Selection. Jurors are selected at random from a group of people who have been called to serve. In the United States, most citizens who are 18 or older may serve on a federal jury. Structure. A jury is typically made up of 12 people, but the number can vary. One juror is selected as the jury's foreman, who acts as a spokesperson for the jury. Relationship with the judge instructs the jury on the law, but the jury is solely responsible for determining the facts. The judge also has a major role in deciding which evidence the jury can consider. Okay, that's all we have for you today, students. That's day 1. Come back to check out day 2. Be sure to take your notes and do your homework. Hit that like button and subscribe button, fam. We out. Peace.